Somebody in the comments asked, could I speak about what we mean by beyond reasonable doubt? And yes, I can, because it's an interesting phrase. And it's actually not a phrase that we use much in law these days, except, of course, when we do. But first of all, I need to explain what we mean by the burden of proof and the standard of proof. So there's an old maxim, he who asserts must prove. In other words, if you're claiming something, then the onus is on you to actually prove it. So let's start with a civil claim. In a civil claim, it is for the claimant to prove their case. That is the burden of proof. But what's the standard of proof? Well, the standard of proof is balance of probabilities. In other words, is it more likely than not that the claimant's case is correct? Now, because of the burden of proof, if the judge just cannot decide, if it's like 50-50, then the claim fails because the claimant has failed to prove their case. It's not really for the defence to prove anything, they just have to undermine the claimant's case. I mean, sometimes we talk about like 51%, 49%. I mean, that's, you know, it's very hard to put numbers on this. It's just like I say, is it more likely than not that one version of events is true? So that's in a civil case, although sometimes, and we'll come on to this, sometimes they apply the criminal standard of proof. But what's the criminal standard? Well, again, if you want to prosecute somebody, the burden of proof is generally on the prosecution, but they have to prove their case to the criminal standard. And now the criminal standard is so that you are sure, whether that's a bench of, magistrates bench, a district judge, or a jury. But where does sort of beyond reasonable doubt come from? It's interesting because I looked into this to see when it was first mentioned, and it seems to have arisen possibly in the 17th century, possibly in the 18th century. But prior to that, the sort of starting point was, well, you've all come here to sort of, argue a case. We'll start sort of, we'll start on a neutral ground. It's like, I don't know if you're telling the truth. I don't know if you're telling the truth. I don't know whose claim, we start with. But now we have the presumption of innocence. Now, interestingly, the presumption of innocence, which means the starting position is that in a criminal case, the defendant is innocent. They do not have to prove a thing. It is for the prosecution to prove that they committed the offence. But the actual presumption of innocence, the first sort of European tribunal that ever applied to that was the Spanish Inquisition. Inevitable, I bet you didn't expect that comment. But yeah, the starting position for the Spanish Inquisition was, you are completely innocent, we need to prove our case. And people started talking about, you've got to prove it beyond doubt. And then it became, you've got to prove it beyond reasonable doubt. But what is reasonable doubt? As Lord Denning said, I mean, theoretically, it's not absolute doubt. Because there's always, oh, aliens made me did it, or something like that. But Denning basically said that if the answer to, have you proved this beyond reasonable doubt? If it's a case of, well, is it possible that, some explanation, some defence? But the answer to that is, well, it's possible, but it's not very probable, is it? Then that counts as beyond reasonable doubt. So it's not, beyond all doubt. However, in the 90s, because we got this idea that we should just use ordinary language, because, beyond reasonable doubt, like I said, people have argued about exactly what that meant. So we shifted to when it comes to instructing juries and indeed magistrates, because they're instructed by their legal advisor, the former court clerks. The test now is so that you are sure. And the idea is, well, that's just an everyday, common sense, normal English word. Are you sure about that? Well, yeah, I am sure about that. I'm not really sure about that. That's the test. Now, there were some attempts, some judges would try and give an explanation as to what that meant. And they'd say things like, sure is when you make a major life decision, like, if you're going to buy a house, are you sure you want to buy this house? Are you sure you want to invest that money? The Court of Appeal said, no, stop doing this. Stop trying to amplify it or explain it. I mean, not least because apparently there's this thing where most people spend less time deciding whether they want to buy a house than whether they want to buy a pair of jeans. They sort of in the first 5 minutes have decided, yes, I like it, no, I don't. So the Court of Appeal has decried any form of amplification. So they say, no, the direction should just be so that you are sure. Now, a lot of judges will say, you may have heard of beyond reasonable doubt. It's the same thing. But there was an interesting appeal, post-90s appeal, where the judge just gave the beyond reasonable doubt direction, didn't say, the test is so that you are sure. And that went to appeal. Now, the Court of Appeal disallowed the appeal, but they did say, decry that use and said, look, judges, for future reference, just stick to so that you are sure. And in what we call the bench book, now called the compendium, which is the sort of list of standard directions for judges, and it's got all the general ones about how to direct a jury on sort of, unanimous verdicts, majority verdicts. It also gives standard directions for lots of offences, how to explain theft to a jury, how to explain robbery to a jury, how to explain murder to a jury. But that just says, just give the direction so that you are sure. So like I say, we don't actually use beyond reasonable doubt now with juries. However, it still crops up there. So say, for instance, Section 76 of PACE, Police and Criminal Evidence Act 1984, that says that if there is a challenge to the admissibility of an interview, the interview cannot be admitted unless the prosecution prove, and it actually says beyond reasonable doubt, that it wasn't obtained through oppression or inducement, threats or inducements, coercion. So there we actually still apply the test. I suppose the argument is, judges, they can do all the mental gymnastics and they're good at interpreting the law and words, so we can trust them to know what beyond reasonable doubt means. But sometimes, the burden shifts. Now, when it comes to a criminal prosecution, the prosecution have to prove every element of the offence to the standard. So, say for instance, it's theft, dishonest appropriation of property belonging to another with intention to permanently deprive. Every element of that has to be proved, so that the jury are sure. So the jury are sure it was a dishonest appropriation, that the property belonged to somebody else, that the person who took it intended to permanently deprive the person of it. But what if it's something like you're up for a GBH or an ABH or an assault, any sort of use of force? Well, the definition of GBH, it says unlawful wounding. So what does unlawful mean? Unlawful means it wasn't done in self-defence or defence of another. And if you raise self-defence, that's all you have to do. You don't have to prove you were acting in self-defence. You just have to say, I was acting in self-defence. And it is for the prosecution to prove, so that the jury are sure, that you weren't acting in self-defence. However, there are some what we call Section 101 offences where the prosecution only have to prove certain elements of an offence, but then there can be a defence to that. So say, for instance, bladed article. It's an offence to carry a bladed article unless you have a good reason for doing so. So what does the prosecution have to prove? All they have to prove is you were in possession of an article that ticks the description. So it's a blade that's more than 3 inches long, or it's a blade of any length that locks. If they can prove that, you are guilty of the offence unless you can show you had a good reason. And it is for you to show that, but only to the civil standard. You don't have to prove beyond all reasonable doubt or so that the jury is sure you had a good reason. You just have to show that it's more likely than not you had a good reason. So it's like, yes, I have this because I am a carpet fitter. And if the jury think, okay, that seems, I think on balance, it's, that's reasonable. I think it's more likely than not that that's a good reason. Then, that is enough to raise the defence. Also, when it comes to the criminal standard, sometimes in civil proceedings, if there's an allegation of criminality, then the argument there is that it has to be proved to the criminal standard. Now, that's not for every case. Say, for instance, somebody's brought a civil claim for an offence. We've seen this where people have brought, claims for, the R word or any sort of offence. they only have to prove that the offence was committed. They only have to prove it on the balance of probabilities. However, in things like disciplinary proceedings, where there's, you're applying the criminal standard, or indeed in contempt, whether that's civil contempt or criminal contempt, but even in a civil contempt, and as I said before, it's rather confusing in that you can commit a civil contempt in relation to a criminal trial, and you can commit a criminal contempt in relation to a civil trial. But if they're arguing it's criminal contempt, then they have to prove it to the criminal standard. In other words, again, so that you are sure. Now, what sort of evidence? They used to say that if with the criminal standard, with the civil standard, alleging an offence. So we're back to the case now where you're just trying to bring a claim against somebody it's a civil claim, but for something that's also a criminal offence. So you only have to show it on the balance of probabilities. They said yes, but the amount of evidence you need to prove that to the balance of probabilities might be more. I mean, in America, they talk about cogent evidence in civil proceedings where you're alleging a criminal offence. The idea being that, crimes, people generally don't commit crimes, so therefore, you need more proof of that. I mean, the example they used to give was, if I say I saw a dog in the park, then the amount of evidence that you need to prove that might be less than if I say I saw a lion in the park. However, there was a recent case that actually said, no, actually we've been getting that wrong. They said there's nothing unusual, people commit crimes all the time. So you don't need to actually show, any extra evidence. It's the same test whether you're alleging somebody did something that's a civil offence or somebody did something that's a criminal offence. But there you go. So like I say, we talk about beyond reasonable doubt. We don't actually use that as a test anymore. We use so that you are sure. And that's just an ordinary English word that we do not try to qualify. So there you go. Hope you did find that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm just in the woods again. What's with the eye patch? Basically, decades of not being quite as good at martial arts as I think I am has left me with a series of injuries. So posterior vitreous detachment there, obviously broken nose lots of time, 23 on my own teeth, dislocated xiphoid process, but also edema in this eye. So about every month I have to go and have a little injection in my eye to sort of like dissolve whatever in there that puts pressure on my retina. And the thing is, it's actually, it's quite a nice procedure. It doesn't hurt or anything, but it's a great excuse for there's lots of dogs in these woods. This is dog walking wood. That's why I like to come here, because I get to play with all the dogs. But yeah, once a month they do that injection in my eye, and I use it as a great excuse for a skive. So the great thing about that is I can literally say, when I sometimes say, I'd rather, avoid this meeting, I'd rather have needles stuck in my eye, that is literally true.